Welcome to an oral argument session of the Fifth District Court of Appeal. I'm Judge Cohen out of Orange County. We've got Judge Brian Lambert out of Marion County, and we are honored to have with us Judge Robert Siegel out of Brevard County, sitting as an associate judge with us this morning. We've got case 20-1378, Joseph White, as personal representative of the Marks estate versus Nicole Marks. Both sides will be allotted up to 20 minutes each for their oral argument. I have a default of 5 minutes for rebuttal, Mr. Hauser. So if you'd like something different than that, let me know and I'll be glad to accommodate you. So that said, Mr. Hauser, when you're ready, you may proceed, sir.
Good morning and thank you, Your Honors. My name is Robert Hauser. May it please the court. I am from Pankowski Hauser Lazarus in West Palm Beach, Florida, and I'd like to reserve the 5 minutes, so we're good.
Okay.
My clients, the appellants, are the personal representative, Joseph White, of the estate of Donald Marks, and Darla Hall, who's the other beneficiary of the estate. This is a will contest.
We're familiar, with the facts of the case. Although I did want to clarify, it's my understanding factually, that I don't think there's any dispute. Well, let me back off and just say that Mr. Marks had spent some time with Miss Marks's mother when she was a newborn, effectively, and then after that, is it my understanding from the record that there was no other contact until she turned about 22, after she went and got a copy of her birth certificate to get a driver's license, and then after that meeting at the age of 22. There was no further contact until Mr. Marks was in hospice. Is that accurate?
I don't know. That's not something that I can answer on this record because the issue was limitations and acknowledgement. So the degree of this person's interaction with her dad is not something that I am ready to tell you. I might be able to tell you by the time of rebuttal, but I don't know, and I don't want to give you possibly an accurate answer here. I'm prepared to tell you about all the times that the decedent may have done something that's critical to our summary judgment on the question of heirship.
All right. All right. So let's focus a little bit. There are effectively three written documents that are attempted to be relied on, as I understand it. One is, three. There's the birth certificate, and then there's not a daily planner, but something along those lines. And then there's the notation in the will. I know it's not quite a daily planner. What was the phrase that was used for that?
I'm happy to call it a daily planner.
Or whatever. We know what we're talking about. Now, it strikes me that the daily planner and the notation in the will didn't refer to Miss Marks as daughter, but referred to as adoptive daughter, correct?
That's correct.
So in terms of the actual acknowledgement of paternity, wouldn't we be left then with only the issue of the birth certificate?
Right. Well, it was my conclusion and my view after studying this that because it says adopted daughter, it's an admission that she's not the biological daughter.
And we certainly know that she was never adopted. Right.
We don't need evidence for that. That should be a matter of judicial notice. Okay. So then the other issue is we know she wasn't adopted, and the decedent is conceding that she's not a biological child. So yes, if the court's asking me, do we discount the daily planner and the will that refers to her as a mere adopted child, which by the way we know is not correct, yes, then the only thing you would look at as an acknowledgement, I suppose, would be the birth certificate. And
Right.
in
So let's talk about that. Now that I believe that the appellee concedes within their brief that the trial court was incorrect in referring to that as an acknowledgement. Are we on the same page there?
yes, sir, it's page 23 of the answer brief where
So-
they
All right,
that
go
it's-
ahead.
so they've confessed that the trial court.
That would leave then, if it's not an acknowledgement, the most that they could be left with would be an argument that it's prima facie evidence. Right?
Right. They're
And-
saying we believe we can get our foot in the door past summary judgment of paternity with a birth certificate, and they did cite a case for that proposition. And from our perspective as the appellants, because we're not arguing actual paternity here, because actual paternity is actually conceded not to exist. And one of the first things I was going to tell the court was Donnie Marks is not the biological father of Nicole Marks, who is the appellee claimant. It's conceded in her deposition that she's not the biological daughter.
Right. I understand that. And
So-
we know she's not the adopted daughter.
So back to the question, Your Honor asked me, well, does she have a birth certificate that shows that maybe she's the prima facie evidence? Yeah, but in this particular litigation on summary judgment on this record, we know as a matter of fact
Right.
that birth certificate is not correct.
And yet the trial court granted summary judgment, effectively finding that she was the daughter for purposes of standing, correct?
That's correct. And what really matters for this court to get involved is that she finds her to be the intestate heir, because that's an appealable order. And it's because she's the intestate heir, she has standing to sue us to try to invalidate the will. And
if successful at that, she would take the entirety of the estate.
Yes, sir. If she knocks out the will, she would, according to this trial court, she would get the whole estate.
Okay. All right. Then go ahead and let us know. Yeah, I think we understand the issues. Go ahead and talk about the statute of limitations, which I guess would be preliminary, and then you can go ahead and talk more about the birth certificate.
Right. So our positions really are interlocking, which were, number one, she's barred by the limitation period. And by the way, she doesn't have a acknowledgement for purposes of the statute, even if the limitation period were not this initial threshold bar. And it all comes from Estate of Smith. And Estate of Smith was construing the statute as it existed up until 2009. And that's the statute that governs here.
And you can't, and we understand, and you can't resurrect a cause of action.
That's right. So there's people like Mr. Marks, the decedent, who were walking around believing they were free of potential claims and causes of action for paternity, and that's a vested right that can't be taken away. And in Estate of Smith, they held that 9511 applies to any paternity action, regardless of the purpose for which it is brought. So any paternity action, and we believe that the words any paternity action means any paternity action, not just some paternity actions. The court went on to say there's no provision in the probate code which removes paternity adjudications brought in probate from the general statute of limitations. It was 9511(3)(b). So therefore, section 9511(3)(b) applies. And the Supreme Court held that the Fifth District, this court, actually reached the same conclusion in its earlier King case, which is another case that doesn't differentiate between the possible theories or manners of proof of paternity. It just held that the petitioner in that case was time barred.
Now, the appellee argues that we don't have jurisdiction to hear the statute of limitations argument. What's your response to that?
Well, the limitation period, you have to decide it to figure out whether Nicole Marks is an heir or not. It's like any other claim. If the determination of heirship on summary judgment is final, and it is as far as this trial judge is concerned, she's held that Nicole is the legal daughter and has standing. If that's a final order, you can only review that by figuring out whether the claim is or is not barred by the limitation period, among other things. She might not be the heir for other reasons, but the main reason that we're advancing is limitations. So they're interlocking. The result, the final order, is heirship as defined by statute.
And to do otherwise, would that finding be law of the case?
I'm sorry, if
Would
the court
would that be law of the case if we don't address she granted summary judgment, really striking your affirmative defense? Would that be law of the case if nothing occurred, if we don't address it?
If you have jurisdiction and on de novo review, you affirm the summary judgment, then yes, that will be law of the case. If you agree with the appellee that you never had jurisdiction, then this issue will just go away and it could be revived at a later date if there were a final judgment that we needed to appeal. But after studying this and the plain language of the rule and the court's Wallace versus Watkins case, it seems absolutely clear that once a trial judge decides heirship, it's considered a final order and probate and guardianship is a strange world that we live in. It's not like a civil case. There are determinations that are considered final in probate that would never be final in a car crash or a medical malpractice civil case. And so paternity is one of those things that's always been considered final, even before the adoption of the rule in 2012, 9.170B5. And this court's Wallace versus Watkins case is basically the review of a non-final order opening an estate. And this court held that it had jurisdiction under rule 9.170B5. So, and I know that the court didn't use the word standing in Wallace, but the reason those people had standing to ask for their estate to be reopened in Wallace versus Watkins is because they were adopted. So it's a standing case. And frankly, the court explicitly held that it's an heirship case. So heirship creates standing. It's something that the court reviews under 9.170B, even in the middle of a pending probate.
All right, let's talk a little bit about the, I'm sorry, Judge.
Yeah, she wouldn't have standing right now to proceed unless she was an heir. So that's
right. That's it. Yes.
Okay.
You have a question?
Talk a little bit about the birth certificate.
Sure. The birth certificate is not signed by the decedent. So it's not an acknowledgement of paternity. And the birth certificate was not presented to any court within the time limit under the old statute of limitations. Like Nicole's mother could have used that birth certificate and perhaps other documentation to try to establish paternity either against Donald Marks or against her real father, the gentleman named Michael Macklin, who we know is the biological father, and no action was taken to do that. And then Nicole Marks, between the ages of 18 and 22 up until 1992 as an adult, she could have taken action with that birth certificate to try to establish that Donald Marks was her dad. And she didn't do that. She may have declined to do that because she had actual knowledge that he was not her father. But in any event, that could have been done, and it wasn't done. So in 1992, under Florida law, which controls the law for this decedent who was domiciled in Florida, so we're really operating under our own Chapter 732. When our decedent died under Florida law, we apply our Chapter 732, and our Chapter 732 is restricted by our Chapter 95, and under our Chapter 95, the birth certificate, like any other potential methods of prima facie proof of paternity, went away. And Nicole's theory that basically any scrap of paper might get her in the door is especially dangerous, but I don't think the court has to go there, given that I think the court is comfortable that once it said adopted, it was not a assertion of biological paternity, whereas the birth certificate sounds like an assertion of biological paternity, which is the thing that Estate of Smith says triggers a limitation period. So there's a whole class of people walking around believing they're free of such claims, and there's a whole class of people like Nicole Marks whose claims have expired. So
even if it were to be prima facie, if you had evidence conflicting with it, such as the deposition testimony of the individual claiming to be an heir. How do you grant summary judgment in that context?
You're right. No, there couldn't have been a summary judgment on actual paternity, and of course, we believe that was error, but we don't want to have a trial on actual paternity because we like a decision that confirms what we've been saying all along, which is that the limitation period has expired and the claimant does not have an acknowledgement that would get her in the door under paragraph C of the statute, even if there was no limitation problem. So that's really our position. But of course, yes, there couldn't have been a summary judgment. But that only gets us only so far of the way. That would doom us to a trial in Ocala in the middle of a pandemic over a will contest. So we don't want to.
Wants to go to Ocala.
Apparently, it's a very nice place. They haven't sent me yet, but I bet that's coming. So I have 5 minutes left. So I'd like to. I'll sit down, so to speak, and reserve my time.
All right, Mr. Douglas. You have to unmute, or we can't hear a word you say. I still can't hear a word he's saying, and he's unmuted. That's all right. We have our second technical issue. I think maybe this is Siegel's fault. I'm not sure.
My microphone is working correct.
Yeah, yours is good. Mr. Douglas, I don't know what. All right. Well,
can you hear us?
Can you hear us? All right. We're not hearing you. All right, go where you need to go. I think you said I need to go to the restroom, but I could be wrong about that.
I only trust Apple products for these things. A Microsoft computer will let you down every time.
Well,
Mr. Douglas, you may need to select the microphone as the one that you're actually using.
Can you hear him now?
he hasn't said anything yet.
Okay. All right. What's going on?
I just turned this mic on.
Okay. Can you hear me now?
Yes.
Okay. Great.
All right.
All right.
We
Thank
got. See, all you needed
All right.
was someone closer in age to a teenager to help you. That's it.
Absolutely. I would have my kids here if they weren't in college, but
Okay.
hey, please support. My name is Alex Douglas. I'm with Sheffield Loman in Orlando, and I represent Nicole Marks as the appellee. Judge Cohen, you are correct with regard to the facts. Nicole's mother met up with Don after he got back from the Vietnam War. This is all in the record based upon Nicole's testimony, and also the testimony of Don's brother, Ron.
Okay.
And after.
Yeah, there was, he was in her life when she was a newborn. She saw him once at 22, and then once when he was
and then he actually searched for her, asked his friend to go find her, and that's how they got reacquainted when he was in hospice.
All right, so
before we get to,
I want to talk about the three documents that you're relying on, because it strikes me that two of the three of them don't do you any good.
Your Honor. Sure. I'll address that right now. So with regard to 732-108 paren 2C, the issue is one that's determined by the father in terms of when he acknowledges the child. And this is why also the statute of limitations does not apply here. This is very different from sections A and B. So there's three ways for an heir to inherit under 732-108. One is a paternity action. And that is what the Supreme Court the first ECA in Thurston addressed. The other is the the ceremony of the natural parents before or after the child is born, and that requires a paternity determination of who the natural parents are. So both section A, which is the marriage ceremony, and section of the natural parents, and section B is a paternity action. Both of those clearly require blood work. It shows biological connection matters. But section C has nothing to do with biology. Biology is irrelevant under the intestacy code for section C. All is required is an acknowledgement by the father. And that's a question of fact, and that's a case.
But it's, excuse me, Mr. Douglas, it's not an acknowledgement that she was an adopted daughter, because we know that's not true. It has to be an acknowledgement that he was in fact the biological father of the child, correct?
Well, it's an acknowledgement that he is the father. Biology doesn't play into it because under the Holman, Sanders, and Nahr case, the father acknowledged the child, but the court said no evidence of actual DNA or blood work is relevant because the inquiry stops at the acknowledgement. So,
but it's an acknowledgement that you are the natural father of the child. And here, you know, the two documents that acknowledge adopting that she was the adoptive daughter, that doesn't get you to the point of being a natural child.
Your Honor, yeah, I actually disagree. There's nothing in the statute that says that, in fact, the father has to be blood related to the child. That wasn't the case in Nahr, that wasn't the case in Holman, and it wasn't the case in Sanders. Actually, in Sanders, there was clear DNA evidence that the father who acknowledged the child was not blood related. So under our probate codes, strictly.
But he didn't, but those two documents don't acknowledge being the natural father. They acknowledge being the adoptive father. So it's, and that's a distinction.
I understand your distinction, Your Honor, and I think the answer is that's a question of fact for the trier of fact, because the operative words, as we argue, is daughter. He may have realized at some point that he wasn't, or he wasn't the biological father.
What do you mean at some point? There's never any doubt that he's not the natural father of this child. They didn't meet until after she was already pregnant.
Well, but again, Your Honor,
unless we're using the Bible as authority.
But under the intestacy code, biology doesn't matter under acknowledgement. The father can acknowledge a child. In fact, that's what he did. He said, I am going to take care of this child. He promised the mother that. He told his brother, I'm not going to leave you anything because I'm leaving it to my adopted daughter. So the adoptiveness could have been a recognition that, in fact, there wasn't biology, but he was recognizing her as the child. And that's all that's required under Section C. An acknowledgement under Section C does not mean that the father, in fact, has to be biologically related. And so the use of the terms adoptive daughter certainly could have recognized that they weren't blood related, but he was recognizing and acknowledging her as a child. That's all is required under Section 2C.
So maybe I'm missing this then. So 2 days before I die, I can rip up my will and I can acknowledge 200 people
Yes.
as my children,
Yes,
even if
of course.
they were, born in other states where I was, anything like. And
Well,
then those 200 kids could come in with my actual biological children born in my marriage with my wife and come in and say, oh, by the way, Daddy Lambert is we want to take part of his $4 estate here.
Judge Lambert,
That's how you're reading this. Is that, make sure I understand. That's how
You're
you're
giving-
saying the statute reads.
not quite, Your Honor, Judge
Okay.
Lambert, but you're giving a very extreme.
Mr. Douglas, call him Dad.
Dad, yeah.
Sure. What I'm saying is that it's a case by case analysis. Certainly, you can have ridiculous cases. You can have people with dementia, and certainly those kind of cases, the trier of facts going to see.
So
whether-
let me interrupt you there. So here you've got a case where you've got someone who has had virtually no contact with this guy, has met him, when she was 20 some years old, and doesn't see him again until he's on his deathbed in hospice. And yet she should take the entirety of the estate under intestate succession, assuming that she could establish undue influence. And you don't, and that's not one of the ridiculous cases that you refer to?
No, Your Honor, there is plenty of testimony that will back up these documents. Looking at the case as a whole, there's going to be no question that Don Marks wanted to leave his estate to Nicole. We're now focused just on whether.
Because it seemed to me in the will, he said the exact opposite of that.
Well, what he said, Your Honor, is that I want to take care of her, and I expect that, and I'm requesting that my friend will take care of her. It wasn't, I'm upset with her and I want to leave her nothing. He says, I'm not providing anything for her because
That's exactly what he said. He exactly said he didn't want to, that he was going to leave her nothing, that he hoped that the guy would give her, $50,000. What's the size of this estate?
There's I believe it's over $1 million, Your Honor.
Okay.
But there's a good reason for that, because the best friend was trying to put doubt into his mind as to whether this was the actual Nicole from that he knew from before. So again, that goes into the undue influence. If the trier of fact sees the entire case here, there's going to be no question that this man, Don Marks, wanted to acknowledge Nicole as his child, and it was for the interference of his friend that didn't happen. He wanted to change his will. And Your Honor, it is called a pocket planner. In his pocket planner, Don wrote out and signed on this pocket planner exactly what he wanted to do with his estate. But his friend said, no way. I think the quote is, I own your white behind, and I'm not going to do it. I'm not going to change the will. So there's no question that if this case goes to trial, Nicole Marks is going to present a very compelling case. And this is all that the court ruled, Your Honor. I want to quickly talk about jurisdiction.
She granted summary judgment, finding her to be the heir.
She found that she has standing to get to the courtroom, Your Honor. And I think there's an important distinction here. And this is why we do not believe the court has jurisdiction. Nowhere in the court's order did she say, I find that she is an heir at law. I find that Nicole is an heir at law.
How else does she get to proceed?
Well, Your Honor,
I couldn't come in and say, oh, by the way, I want to be, I want standing too. And they grant me standing, and they'll say, what basis do you have standing, Lambert? Well, I just want it. I'm not an heir. I'm not nothing.
But Judge Lambert, you make an excellent point. You have to
Really? I
allege
didn't think so.
sufficient ultimate facts to show why you should get into the door to the courtroom. And that's all the judge is saying, is that, look, we're not proceeding under section 2A or 2B. This is not a paternity determination. This is a determination under 2C as to whether there's sufficient evidence of acknowledgement. All the court found was that you have standing. What she found, Your Honor, is that the affirmative defenses that were raised were inadequate. They were not proper affirmative defenses. It's a common practice for people to raise affirmative defenses that are not proper affirmative defenses. Standing is one of them. It's the plaintiff's duty.
How about statute of limitations? Is it a proper affirmative defense?
That is a proper affirmative defense, Your Honor.
But you struck. She granted summary judgment and effectively struck that.
Because it's the action of the father that determines when the acknowledgement occurs. He can acknowledge a child as late as his deathbed. And so it would be against public policy to take away a right of a father under section 2C to acknowledge a child at the time he wants to acknowledge it. This is not controlled by Nicole. She can't control when the father will acknowledge her. He has the right to acknowledge her all the way up until the time he dies. So the statute of limitations.
Wait a minute. Yeah, she had possession of that birth certificate when she was 20. Well, actually, probably at 18 when she went to get a driver's license. So at that point, she had complete control over that.
Well, that's Your Honor. That would be only to compel the father to pay support. This is not about support. The statutes that the appellant relies upon under family law and under when you can put your name on a birth certificate, they're totally inapplicable, because this is not about trying to get a father to pay child support.
He wants to be an heir, considered an heir for purposes of estate planning. She had the absolute ability to control the timing on that.
She has no ability to control when her dad acknowledged her in writing, and that's only the father can control that. The father here acknowledged her in writing, in his will, and in
but that's what he didn't acknowledge that he was her natural father in the will. He uses the term adoptive daughter, and we know without really any conflict that he never adopted her.
But Your Honor, again,
that's like do you have, when you were a kid, did you have friends of your parents that you referred to as uncle?
Yes, but Your Honor, coupled with the testimony that is going to back up these written acknowledgments, it's going to be really clear to a trier of fact. Don Marks considered Nicole his daughter. The fact that he used adoptive does not preclude the fact that he acknowledged her. And as I emphasized, biology has nothing to do under Section 2C. That was the situation in the Sanders, Pullman, and Nahr case. If biology precluded a father from acknowledging a child, then in Sanders, the court would have said, the DNA test came out affirmative. Therefore, even though he acknowledged the child, then he cannot be the father because the biology contradicts it. Same thing in Holman. They didn't allow blood tests that would be introduced to show that the father who acknowledged the child wasn't really the father, because biology under Section 2C has nothing to do with whether a father may or may not acknowledge a child. And so the other part I want to make really important, Your Honor, is that under New York law.
Let me make sure I'm clear again now. So I have a daughter, biological daughter, born during my marriage to her mom. So you're saying that my daughter could now convince the next door neighbor where she lives to acknowledge her as her father as well. She would have two fathers, so she can inherit.
That would be undue
influence. Inherit
influence
from the other guy.
That would be undue influence, Your Honor. Certainly.
Okay. All right. Let's not walk that one here. That guy comes to my daughter's house and says, I don't have a daughter of my own. You seem like a nice person. I'm going to acknowledge you as my daughter. I got $1 million estate, and if I die, I want you to get it. So I'm going to acknowledge you, my daughter. My daughter says, I have a dad already.
That's right. That's why he couldn't. And that's why he couldn't. But no other person has acknowledged her as a father. No, the father who they believe is a father. There's no proof that she has who her natural father is. She thinks she knows who her natural father is. He was never ordered to pay child support. That was found in the court order. No one has been ordered to be or had. No one has been determined to be her natural father. No one. So when you have a situation where you have a natural father, you cannot, another man cannot acknowledge.
Wait. The only way that she can know all this, and of course it's kind of a tangential issue here. The mother had to have told her these things. That's the only way that she could know about this, is by mom sitting down and talking and telling her. And so the mom told her, I used artificial insemination. I had a sperm donor, and this is who it was, and that's who your father is. So to say that, there's no evidence of it, sure there is. There's it's your client's testimony.
Well, there's no adjudication of who her natural father is. And my argument is, if there's no adjudication of who your natural father is, if another man wants to acknowledge you as a child, that man has the right to do so. And that's what happened here. The other thing is that the only way Don Marks.
Well, but couldn't he have just done that by giving her money? Couldn't he have put, said, it doesn't matter whether, it's a daughter or whether it's Judge Lambert. He could have put in his will, I am leaving my estate to Nicole Marks. He could have done that.
And we think that's what he intended to do, and that's part of the undue influence case. Again, when the trier of fact sees the full set of circumstances here, we believe there's going to be no doubt that Don Marks wanted to leave his estate to Nicole. We have shown that we have standing to go to the courtroom. And at the courtroom, we're going to be able to show all the elements that we are an heir pursuant to 2C, that there was undue influence, and therefore we would benefit if we show that the will should be set aside.
All right, so the statute of limitations that talks about any proceeding, that doesn't apply to you.
That does not apply to us, Your Honor, because this is not a proceeding. This is a written acknowledgement by a father. Section 2C is controlled by when the father acts, not by when Nicole acts. I certainly agree that if Nicole instituted a proceeding to determine who her natural parents are, or to determine who her biological father is, that's a paternity action, and that is barred by the limitation.
You don't think that's exactly what's occurring in the probate case?
Absolutely not, Your Honor, because again, it's nothing that Nicole did. It is what her father did. Don is the one that acknowledged her in writing. It's his action that precipitates when the acknowledgement occurs. The other thing, Your Honor, is that a trier of fact can infer from this birth certificate under New York law that the only way Don Marks' name could have appeared on the birth certificate pursuant to New York law was if he signed an affidavit. That's the only way, and we cited the New York statute, that's the only way his name could have appeared.
Right, and that affidavit would say, I was the natural father.
I don't know what the affidavit would say, Your Honor.
Well, neither
That's
do
the
we.
law of the state of Florida too, isn't it?
The law, that's right, Judge Siegel, the law of the state of Florida right now. And by the way, the statute of limitations is gone. This is only because we're proceeding under the old statute. The new statute of limitations does not apply to bar paternity actions in the probate arena. Okay, so this is the old statute. We wouldn't be talking about this if this happened after the change. But
Right.
you're
But
correct, Judge. You're correct, Judge Siegel, that just like New York, in Florida, the only way your name as a father gets on a birth certificate is if you signed a affidavit acknowledging this is my child.
All right,
So a
where's
trier of fact,
but we don't have that affidavit.
but a
right?
trier of fact can make the inference. And this is why there was harmless error, Your Honor, because the judge went ahead and made that inference. She can't do that on a summary judgment. She could do that at a trial. She could say, look, I infer that because the only way under New York law the name could have been on there is an affidavit. I find
This
that.
was summary judgment.
I'm sorry?
This was summary judgment.
Correct. So it's harmless error that she made the inference because there's two other written acknowledgments. There's actually three written
All right,
acknowledgments.
you're wrap it up because you've exceeded your time.
Sure. There's three written acknowledgments we would argue at trial. One is the inference the trier of fact can make by virtue of the fact there is a birth certificate with Don Marks as the father. The second is the pocket planner signed by him.
We got that. We understand that. All right, Mr. Hauser.
Mr. Hauser, let me ask you this. If there is a duly filed birth certificate in the state of New York, why doesn't that then create a rebuttable presumption of paternity that would have to be rebutted by your client?
Because on this record, it's undisputed that he's not the real father. And there could be a case, especially a more recent case after 2009, where a birth certificate
But
might be
doesn't
used.
but doesn't that birth certificate get her in the door and get you past the statute of limitations to the point where then your clients have to come in and say, look, we can rebut this. We have to argue this here in this court, but she's entitled to raise this issue because there is a presumption created by the fact of her name on that birth certificate.
I don't think so, because I think we need to distinguish between something that tends to prove that the decedent is the biological dad of Nicole Marks.
But I mean, isn't that the state of New York and the state of Florida? Is that name on the birth certificate, that signing of the birth certificate, it implies that there's been this acknowledgement signed that that person's accepting the responsibilities of paternity.
Okay, so now there's two layers there. The birth certificate itself is only possible evidence of birth and possibly evidence of paternity. But in our case, again, it is undisputed, even for purposes of a summary judgment in our favor, that he's not the dad. Now, the second part of your question is, okay, what if somewhere there was also an affidavit, and let's assume that in that affidavit, Mr. Marks swore, by the way, fraudulently and falsely, because he knew it wasn't true. Let's assume that he fraudulently and falsely assumed that, swore that he was the father. We've all tried to get that affidavit from New York. The other side tried to get it. We tried to get it. It doesn't exist. So there's no inference to be drawn that someone would file a false and fraudulent affidavit in New York to get a birth certificate. We have no idea how that birth certificate was manufactured. There's no testimony about how that birth certificate was manufactured. The evidence that's in the record is just the birth certificate.
But
And
again,
so
doesn't that get her in the door and get to the point where you have to rebut that?
it doesn't first of all, it doesn't solve the statute of limitations problem at all.
Why not? I mean, wouldn't the acknowledgement have been executed back on the date that it was filed?
But it was never presented to a court to create paternity. It was never used to get child support. It was never used to establish paternity in any sort in any prior judicial proceeding.
But that's another subsection under the statute. This simply says the paternity of the father is acknowledged in writing. It doesn't say that there's been an adjudication, that there's an obligation to pay child support. It says that there's an acknowledgement in writing. And that acknowledgement in writing could only appear on the birth certificate if the person had signed a sworn statement saying, I am the father of this child.
Assuming we have to assume that happened in order for the court's hypothetical to work. We have no evidence
that was part of the record. That
There's
New
no
York
evidence
law was introduced. Florida law seems to say the same thing.
Right. There's no evidence whatsoever that such an affidavit exists in the court files of New York, even though everybody asked for it. So the fact that it doesn't exist and the fact that it would be false and fraudulent if it did exist both support the reversal of the judgment. It certainly doesn't.
You could, as a matter of goodwill, assume the responsibilities of parenting a child.
Right.
I mean, that wouldn't make it fraudulent.
Sure, because it would have deprived the real father, Mr. Macklin, of his parental rights, even though he is the natural father.
As far as we know, from what I read, there was a sperm donor.
On this record, he's the natural father, not the decedent. So it's undisputed on this record, even at summary judgment, that Mr. Marks is not the father of Nicole Marks. And that's even admitted by Nicole. She's traveling strictly under some a legal theory that she could be acknowledged after the limitation period expired, notwithstanding her lack of actual paternity and lack of adopted paternity. During my opponent's presentation, I noticed there was a discussion about adoption. 732-1081 is the section that deals with adoption. An acknowledgement has to be a acknowledgement of biological paternity. Otherwise, it would only be relevant under subsection 1. Under subsection 2C, the paternity of a father acknowledged in writing has to be biological acknowledgement. And the reason why is that at common law, and really only until recently, paternity was a big deal and it was hard to prove. Now it's easy to prove, and there's really no longer a reason for a limitation period. So in the post-DNA world, biological paternity is something that doesn't need a statute of limitations. But up until 2009, there's a reason why we locked people into their positions within 4 years of majority.
All right, Mr. Hauser, your time's up.
I need to wrap it up. We urging the court to reverse the summary judgment and remand with instructions to enter a judgment holding that Nicole does not have standing as an heir to contest the will.
All right. Thank you both for an interesting argument, and we'll be in recess.
Thank you.